Motion to approve the agenda. Second.
All right, we have a motion to approve the agenda. Any discussion? All right, all those in favor of the agenda as presented?
Aye.
Unanimous, thank you. All right, public comment on any items not on the agenda. I think I can see everyone in the room, but tell me if I'm missing anything.
Yeah, I'm not sure who's in the audience, John. We've got front row with the Allens and Andrew Winter, and 3 folks in the back.
Okay, well, if people are there for agenda items, then we'll move forward. On the correspondence, the only thing that's in the correspondence was a note about the cannabis survey. Now you can see from those emails where my initial response was, I can't fill out a survey without putting it before the PC. I then got another note a little while later that said, you know, that the deadline for the survey was a week or so ago. And so I looked at it more closely, and it was easy for me to fill it out factually. It was just statements about does your town have a zoning ordinance relating to a cannabis growth area, and do you have any zoning bylaws that, you know, so I was able to just simply factually answer the questions. If you see in his notice, I believe there's some kind of a public municipal event in October, but unless I'm missing something, I have not heard anything about pot growing operations in Norwich being a big topic that we're gonna put in front of other priorities. So that's all that we had in correspondence.
Yeah, hey, Jan, can we get the names of the 3 folks in the audience for Vince?
Oh, yes, please.
My name is Marcia Price.
Earl Simpson.
Peter DeShazo, DE capital SHAZO.
Can you spell that one more time, just to make sure? Can you spell your last name one more time?
Sure. DE capital SHAZO.
I got it. And your first name, Peter? Okay. All right. I think we're good, Jan.
Okay, good. Thank you. Next item on the agenda is lot consolidation and merger. We've had this bubble up and bubble back down, and I think we should be able to address it tonight if at all possible. Maybe Cheryl, I'll try quickly to summarize what I think we're talking about, and then you can correct me and clarify. We have what appears to be whether it's a difference of opinion or just a difference of situation between what the listers and a variety of legal opinions say relative to whether a merger of 2 lots or a consolidation of 2 lots requires a permit from the DRB. And the last 3 zoning administrators from Stephen Bauer, Rod Francis, and now Kyle say that based on our regs, they're not saying it's correct, but based on their reading of our regs, because there's no independent definition for merger or consolidation, it comes under the heading of boundary line adjustment, which then flags a hearing required. Whereas if you saw in the packet, some pretty strong opinions from both applicants and their lawyers to say this is not necessary, and can we please do something to clarify it. So that's my understanding, Cheryl, and I think if
Jan,
yeah, go ahead, Jim.
Yeah, before we yield to someone outside the planning commission,
Sure.
can we have a planning commission comment or two?
Sure, please be my guest.
Yeah,
That's
yeah,
as
so,
much background as I'm worth giving, so.
Yeah, your
Feel free.
background seems fine to me. So bottom line is, we don't have anything that defines this merger paradigm. So to me, it's kind of simple. We should look at how we offer some nominal language change to accommodate a merger of two parcels. I don't need anybody else to weigh in based on my years of experience. I think this is an appropriate approach. And the next question is, can we just flip this to select board to codify it?
So can you be more specific relative to language, that we're talking about just putting a definition of merger to separate it from BLA or?
Well, right now, there are questions about in our subdivision language and our zoning ordinance. And I want to be clear, I'm going to continue to refute the notion of bylaws. We have a zoning ordinance and a subdivision regulations and a town plan. If we have bylaws, those are what guide us in our meetings. Having said that, we don't have anything that governs how lots can be merged. Therefore, the de facto review is DRB based on the closest, which appears to be BLA. Whether I agree or disagree, it's irrelevant. We can change the language to say if someone wants to merge two parcels, here's how you do it. It's administrative done.
Mm-hmm. Other comments, questions from members of the PC? Okay. Cheryl?
Yes, thank you. And Jeff, I'm with you, but I would like to remind you that the statutes allow for this, and therefore there can't be more restrictive regulations by a town. And that's where we've bumped into this. And the listers get caught in the middle because, well, not any longer with Jack Candon, but Jack was ready to take the town to court over this issue if we didn't let somebody merge. And it got very dicey and it's uncomfortable. And so with that said, and the letter from the attorneys, there is a consolidation deed that can be filed and the merging of parcels can occur. The last thing I'll say is, if zoning doesn't recognize that, we end up with two departments in our town that have two different numbers of parcels for a property owner, and that gets dicey. So we need to be on the same page. We need to satisfy the needs of each department, and going to the DRB is not required, not necessary. It's a consolidation deed that can be filed and passed around to the departments, and everybody should be satisfied, I think.
So can I ask the PC, because I'm not hearing anybody disagree with the idea that you should be able to merge two lots without needing to go to the DRB and get a permit. Is that the consensus of the PC? Jeff?
Yeah, so Norwich has a long history of not caring about what state law says, including open meeting law most recently, among other things. I think I tried to transcend everything Cheryl said to just change our regulations to comport with state law. So can we do that?
Well, I want to make sure. So it sounds like we have agreement of the PC. Nobody's arguing for somebody's got to jump through more hoops or even the present level of hoops to merge two lots, and with specific statements like there isn't a house on both of them or that kind of thing. So what we're asking for is the simplest method to implement that consensus, I think is what we're saying. Do I have a hand in the audience?
You
Okay.
do.
All right.
Andrew Winter, Twin Pines Housing Trust. Just a quick question for Cheryl. If there are two parcels owned by a single owner. That merger, had merger take place without a merger deed. In other words, can the listers choose to merge those lots? Do they have that discretion?
We do not.
Okay, I ask only because this has been an issue with an affordable housing property in another community where we're trying to undo that, where the listers did merge two lots with one owner. So if there's a deed, that affirmative action of having to execute the deed satisfies my organization. Thank you.
And just to clarify, the process currently is somebody wants to, they go to zoning. Zoning issues the permit, then it's on hold until it goes to DRB, and DRB has the time and a meeting to review and approve, then it goes back to zoning, and then it's, then it's on to the end, where in fact, the consolidation deed comes to the town clerk. The town clerk's office would be asked to disseminate the deed to, which we always get to the lister's office, but to the zoning office. And we're done.
So we could, if we said, all right, we, the planning commission, propose the simplest possible one-liner update to the zoning ordinance. We can look, we can say, is it a zoning ordinance thing or a subdivision reg thing? But the simplest possible, it's either a definition of a consolidation or an exemption statement around boundary line adjustment. But basically, it makes it clear with a change to the ordinance that mergers don't require permits. Then if that is a small enough change to justify the PC not needing to do a hearing, for example, we would take that, simply give that to the select board and say, this is a consensus of the PC. There is no negative, nobody's arguing against this. The select board would have to hold a hearing. They would have to approve it, but that would clarify it in our regs once and for all is the idea. Jeff?
Yeah, Jan, I think it's both subdivision and zoning, but it has to be a function of whether there is development on the lots. So in the context of one lot developed, one lot not, the merger can occur. If they're both developed, I think it's still a DRB issue. So if it's a question of merging two lots undeveloped, two lots, one developed, one not, I think it can be that simple. Flip it to the select board for a couple of simple changes in zoning and subdivision, and off we go.
Okay. So if we take that as a proposal, and actually this is a good opportunity to give everyone a piece of good news, which I should have done. Well, I didn't do chair notes. So we made an offer to one of the two candidates that this group approved, and he accepted it. So Stephen True will take over as planning director and zoning administrator starting in about 3 weeks. And so we will have staff to help us craft a sentence or two about certain things and get them to the select board in a timely fashion and so forth. So if we take a proposed, the intent would be a minimal change in, if it needs to be both of those regs, then fine, whatever the minimum is that says the merging or consolidation of two lots, no more than one of which has development on it, does not require a DRB permit. If people agree to that intent, then we can do the mechanics of getting the specific language to the select board for them to enact. Cheryl? Is that?
Well, I was just trying to think back of the ones that we've had. maybe there weren't any with a dwelling on each parcel that we've done of late, last few years. But there are parcels that have 2 dwellings on them. I guess they either got merged ahead of time and then built it. I don't know. Well, you can go with that. I'm just trying to
I've
think out loud.
definitely
for a minute.
seen, I don't know where the reference was, but I did see in one of the statements a clear limit that said only one of them can be developed. That
Okay.
it's you're definitely causing a much bigger snafu, or you want a permit if you're trying to take 2 built lots and put them into one, because that's a weird backdoor way to get a PUD or something like that.
Yeah.
It's PRD.
Well, I appreciate this idea because if we're all on the same page in all departments with requiring a consolidation deed or some deed that merges, whatever the wording is, they're giving up their subdivisions. And they have to come back and get permission to subdivide in the future. This will clarify a lot and make it much smoother for all of us. So thanks.
Yeah, and that was another, just again to the intent, it is no more than one of the 2 parcels developed, and it is an abdication of your right to subdivide. You can't just flip a switch and put the line back in if you feel like
Right.
it. It's
That's right.
you would have to do an official subdivision to turn that lot becomes one lot and is indistinguishable from a single lot and would have to be subdivided with a new.
And a little caveat I just thought of is oftentimes from the DRB's meetings, the message to the property owner was file a plat showing that all is on one. And never do they do the deed, which is what the town clerk and the listers want to see, because the listers never got the plat to see that something was done. So it was confusing from the DRB's message. I know in other towns, they'll say, do a consolidation deed and get a plat filed or, recorded. And so there was some disagreement amongst people about what they had to do to satisfy the consolidation. So again, another thing that just popped into my head.
Mm-hmm.
Okay.
So what do people need? Do we need to see this again? Do we need to get some language specifically and then bring it to the PC? Or can we get it together kind of independently, or you can entrust me or me and staff to do it and get it to the PC and we can make a motion to that effect, or we can bring it back at the next meeting? Jeff?
Yeah, and I'll defer to the planning commission, but I think it's important to look at the ordinance and if, whenever Stephen True is going to come aboard, we can look at zoning and subdivision before he arrives. And then, hypothetically, you could flip it to the select board to say, what do you need to do? What do you need from us to advance this as a relatively simple paradigm? And then if need be, the select board may say, well, you guys need to do this or that. So I think it involves both the subdivision regulations and the zoning ordinance. What does the select board need from us? And then we can maybe re-engage as needed.
Okay, so why don't I propose this, because this is a special meeting, our next regular meeting is in 2 weeks. So if I do just the minimum of reaching out to the select board to say, on this topic, we have a consensus statement about intent, that we would like to come up with some specific language and get to the select board. And then I'll come back in 2 weeks to this group with specific language and a little bit of back and forth with the select board in hand. Is that acceptable to people? Okay, great. Thank you. We will do that. It'll be on the agenda for the next meeting. But since nobody's arguing against it, we really should just get this done. Thank you, Cheryl. Okay, Next item on the agenda is farmer's market. We have some information in the packet. At this stage, I would present it as an early, information to the PC, no action required or expected, but that's the agenda item, and I would open it up first to the PC and then to the public. Jeff?
Yeah, I'd say thanks. We'll consider it as we look at zoning changes.
Other thoughts? Bob, Christian, Vince? Okay, Bob?
Yeah, I'll just say, I mean, it was very nice to see the consideration of, potential thought to some level of a housing option in the future. I mean, that is a large lot, even if the farmer's market quadrupled in size, it's still a lot of acreage. So given its spot and potential and whatnot, it's good to keep in mind that or it's nice to hear that there's consideration of potential other parts to it as we look at many other things to as Jeff says, potential changes to the area, or I shouldn't say changes to the area. I mean, consideration of what is the highest and best use, I guess we keep coming back to. So yeah.
Mm-hmm. Anybody else? Vince?
Yeah, just kind of to what Bob was saying with the additional options of housing or anything else outside of what the farmer's market would be. Like he said, there's a lot of space there to have options there. And considering its relationship to sewer hookup and its position next to transit, there's a lot of really good potential there for either affordable housing or senior living or lots of mixed use or anything like that. So if that's the option, it seems like going the conditional use route is less effective if there's going to be a different kind of developed than we originally talked about, of just having just the farmer's market there.
Mm-hmm. Okay. Peggy, you want to say something?
Hey, Jan, before we move off the planning commission, so Bob and I met recently about the so-called low-hanging fruit for the VR district and the infrastructure corridors. And I hope at our next meeting or subsequent meetings, which may be many subsequent meetings, we can talk about where the infrastructure exists and what we want to do within the infrastructure. And in this context, to the extent that we revert to something some years ago that the Planning Commission contemplated, we looked at this entire corridor as commercial and suggested that to the extent housing was proposed, you could do 8 units per acre. And if that's the case, something like farmer's market to me would be a permitted use. So we got to vet all that and maybe bring that all back.
Okay. Maggie?
Can I clarify something that I'm?
Oh, I'm sorry.
I was just saying, I wanted to make it clear that the potential for the site could include farmer's market in addition to the housing. I didn't want to make it like an either or situation. So I just wanted to clarify that. Okay, you go ahead.
What the farmer's market is trying to ascertain is, regardless of whether it's this property or a different parcel of the zone rural residential, what we're trying to do, as I understand it, is that we need a conditional use if it's a rural residential. So yes, this is one lot, but what we're trying to determine is it possible to get a conditional use on rural residential? And you're right, this is a lot that's far exceeds the amount that the market needs, and the market knows that. But what we're here today about, and the purpose of this document, is submitting what would be the definition, and this is what we were told we needed to provide, and we worked with Kyle Cass on the definition. So I understand that there is a question of, the best use for that particular lot, but it was my understanding that our first step was to first determine whether there can be such a thing as a conditional use for a farmer's market, because there's nothing anywhere in the zoning regs for the notion of a farmer's market. So that's what we did, is we provided a definition that we worked with Kyle to create.
Yep. Yes, thank you. We talked about it in a previous meeting, and I asked specifically because I thought that would be, there were questions exactly what were you talking about, what were the other uses that it might be used for, and to have as a piece of background, what do we mean by farmer's market if there is a proposal or thinking to add it as a conditional use in any district. So that's why we asked for it, and it will help us going forward. Jeff?
Yeah, and I think what Peg just asked is a separate issue, but a fair issue from my standpoint. So I don't see this as a conditional use or not. The question is, in our current zoning, do we allow farmers market? The answer is no. And even though Kyle's somewhat new to the process, our regulations don't allow a farmers market, which would be a variance. So to the extent we look at our zoning going forward, I mean, I could see farmers markets in other locations if it made sense. So I think to Peg's point, let's think about what it means to have a farmers market, and depending on how we address zoning, should it be a permitted use, which I think would be the case along Route 5 if we do a commercial setting, or a conditional use if it's in some other setting, like an RR setting, which or a rural residential setting, which blankets the town.
Mm-hmm. I think at least the way I'm seeing it as we start this discussion is that the point is that the definition, the project proposed and so forth is really one piece of input to a much bigger effort to look at the low-hanging fruit for housing, the planning desires of the town, how that we need to, we're going to over the coming months look at that bigger picture, and now we have a specific question and proposal as part of that whole picture. I don't see us, and I haven't heard the proposal that there isn't anything the Planning Commission will do specifically in the very short term to address this specific parcel and this conditional use. It has to be in context, but that's open for discussion. Jeff?
Yeah, and I think it's important that we do not say a proposal, a parcel. What we've heard is someone who wants to propose a farmer's market and offered various contexts for that. If we look at a specific parcel or a specific proposal, which is not within our jurisdiction, we're liable legally, I think, for spot zoning. So let's just say, hey, look, Peggy Allen has come forward and said, how about, and it's a reasonable question, if it's in the Route 5 corridor, that's reasonable. It's not spot zoning. If it's generically, that's not spot zoning. So let's try and engage language that helps us not get sued in the future.
Yeah. Other comments? PC members or the public? Yes, go ahead.
To repeat, my name is Marcia Price, and I am the president of a newly formed not-for-profit called Homes for Norwich. And I would like to support the application of the farmer's market. We would.
Okay, thank you. Any other comments from the public or the commission? Okay. Thank you. I mean, I think, Peggy, thank you for the input. I think it's a good document that gives us the background and the definition that we can use. And again, to Jeff's point, it's not to a specific parcel in the way the planning commission works, but it is certainly to put something on the table that we will include in our thinking going forward. Okay. Next item on the agenda, do I have a motion to approve minutes from September 10? Jeff?
So moved.
Second.
Any discussion of those minutes?
Can
Vince?
I add something first?
Go ahead, Vince.
There's definitely a mix up with versions of this. So I sent out two, and I think the older one got posted. So the obvious one would be, let's see, at the end of number 5, the very last paragraph. Let's see, it says group had consensus, zoning bylaws in order to achieve compliance with state laws relating to just housing. And that was related to multifamily and multi-use housing. So added that word and sent that out, and it got lost at the, so I want to make sure that that's on there.
Okay.
Yeah, I don't think Vince needs to make that. We talked about low hanging fruit, multifamily and other stuff. And then, yeah, my only issue in the minutes going, and I'm not going to correct this because we talked about bylaws. Bylaws is the wrong term. So I'd like to go forward saying something different. And then under capital planning, there's the first sentence, there's no period. I'll leave it at that.
Your point about bylaws is simply that the name of our documents are zoning ordinances and subdivision regulations.
Yeah, town plan, subdivision regulations, zoning ordinance. Our bylaws govern how we treat one another in the public in each meeting.
Right, yeah, we have them, but that's not the zoning bylaws. Got it. All right, any other comments on the minutes? Okay, all those in favor of approving the minutes as amended, September 10th? Unanimous? Any other public comment? All right, I'll take a motion to adjourn.
So move.
All right, thank you. Second, all those in favor?
Aye.
All right, next meeting will be our regular meeting on the 8th. Thank you all. Thank you for coming.